Today's episode of Lone Star Lawyers on the Varsity Podcast Network is brought to you by Varsity Search. Varsity Search builds great teams by connecting lawyers in Texas with career opportunities at small and boutique law firms. So if you're thinking of making a move or your law firm is looking to hire, please go to varsitysearch.com and book a time to visit right into my calendar. Varsity Search, building great teams. Hey everyone, Daniel here back with you on Lone Star Lawyers. I hope you and your family are both healthy and safe. Before we get started, I want to let you know of several opportunities that we are currently searching for. In Austin, there is a family law associate attorney position with an outstanding and fast-growing firm. A couple years of experience preferred here, but reach out to me about that one if that's of interest, especially if you're thinking of relocating, maybe from either out of state or especially from another city around Texas. In Dallas, a junior partner. We don't do much of those here, but if you're maybe in that 6, 7, 8 year range, and you've got some business, and are thinking about where you'd like to, be for the next handful of years or even for longer, and it's not where you currently are, there is an opportunity for you to move over to this firm that I'm working with and be a partner right away, with a low amount of overhead that's reasonable. And if you've got enough business to keep yourself partially busy, there's also business that the firm can give you, and you can grow your own practice from there. And so if that's something of interest, would love to hear from you. Also, finally, in Houston, a high-end litigation boutique, again, 2 to 5 years, preferable here. But these are big law attorneys, litigators, who have been on their own now for 8 or 10 years, and are doing well and looking to grow. So that would be in Houston. And if that's something of interest, let me know. And speaking of Houston, that's where we are for today's conversation with Keith Jaasma. And Keith is the managing partner at Ewing Jones, a full-service commercial law firm where he practices complex commercial litigation and intellectual property law. And Keith has worked at several well-respected law firms over the course of his career, including Baker Botts and Patterson and Sheridan, before joining Ewing Jones. He was the lead lawyer on 2 patent cases that resulted in published opinions by the U.S. Court of Appeals for the Federal Circuit. He has served as a board member for the Houston Intellectual Property Law Association and is chair of the Entertainment and Sports Law section of the Houston Bar Association. All right, with that, let's hop into our conversation with Keith Jaasma on today's Monday Mentors episode of Lone Star Lawyers. Keith Jaasma joins us right now. Keith, thanks so much for taking the time to be with us today.
Happy to be here.
Well, before we get too deep here, I would love for you to share with all of us a little more about what you do and what your firm does, and tell us a little bit about your practice.
Sure. I've been a lawyer for about 25 years now. I'm mainly a litigator by background, or almost exclusively a litigator by background. I started out with a big firm and then ended up at a patent litigation boutique. And so for a number of years, that was about 99% of my practice. And then ended up with more of a patent prosecution boutique where I kind of became the everything else department. So I was doing litigation. That's where I really grew my trademark prosecution practice and copyright practice, and did some transactional work. And so now at Ewing Jones, which is we're about a 15, 16 lawyer general practice firm. We do a little bit of everything. We have some corporate folks and some litigation folks. I'm basically the head of the litigation department. I do about 80% litigation. About 2/3 of that is intellectual property related, be that patents or trademarks or copyrights or trade secrets. And the other 20% of my practice is, some employment advisory stuff, employment agreements, trademark prosecution, copyright prosecution, due diligence related to IP and mergers and acquisitions and things like that. So really pretty varied mix at this point.
Yeah, absolutely. Well, and We're recording this on February 3rd, 2021 for people listening later. And I want to ask you about how things are going as it relates to COVID right now. We're sort of on the hopefully the precipice of getting everybody vaccinated, and that'll hopefully happen throughout the spring. And some people are getting back to work in offices and some aren't, and everybody's clients are a little bit different. So tell us a little bit about what's been going on lately as it relates to COVID.
Yeah, so we basically shut down the office for about 6 weeks, starting in mid-March of last year when COVID first hit. There were probably 1 or 2 or 3 lawyers who would kind of come into the office from time to time during that period of time, which we had a lot of space, so it would be almost absurd if somebody wasn't here. And then I started coming back to the office about 6 weeks after, so really early May, and then for 2 weeks I was sort of half on, half off, and kind of once I got my second monitor moved back to the office, I've been here for the most part since Memorial Day of last year. The other 3 owners of the firm have been here most of the time. And then we really have a mix among the other lawyers in the firm. Some haven't been here more than a couple times in the last year. Others come in a couple days a week. As far as our staff's concerned, we went to everybody remote for 6 weeks. Then we had 1 out of our 7 staff people coming in. Then we went to 2 out of the 7. Then 3, and then back down to 2 and back up to 3. So we sort of have half of our legal assistants and legal secretaries coming in essentially on alternative days. So our office is probably any given day, 40 to 60% of capacity. But we wear masks around the office, and mostly we stay in our offices and don't do a lot of chatting and do some Zoom calls with people down the hall sometimes. Right. So we're all here, but we're not, hanging out in the kitchen or anything like that.
Yeah, absolutely. And as far as the cases and your client matters, that kind of thing, has there been any transition or have things adapted to kind of the online model for most of it? And what are you expecting in the next handful of months or throughout 2021 in terms of things going back in person, that kind of thing?
Yeah, we've had a lot more in-person hearings, at least in the court a lot more remote hearings. At least in the court in Fort Bend County, we had some in-person hearings for a while, and that's kind of gone back to remote again. In federal court, a lot of it was done remotely, though I happen to have a case with Judge Hughes, and he was doing things in person, although in the courtroom as opposed to in his chambers. So it was probably a good 60 feet between us and him in the hearings. We've done obviously more remote. I haven't personally done any in-person depositions since it started. Some people have, but I've done a few remote depositions. I kind of like them for out-of-town depositions because you're done and you're back at your office and you just move on to something else instead of spending 2 days or 3 days traveling to and taking the depot and traveling back. So there's been a real mix, and I think I think a lot of the Zoom meetings and even Zoom out-of-town depositions, at least for third-party witnesses or less important witnesses, I think that's kind of a permanent thing that we're gonna see from here on out.
Sure. Have you over the course of the last 9 or 10 months now, have you learned any kind of tricks of the trade or tips of how to utilize the technology when it comes to the depositions and the hearings? Or are there things that you've figured out that don't work as well and you've adjusted or just anything like that?
Yeah, with hearings, the getting comfortable with being able to share your screen and move pretty rapidly to doing that, that is a good skill to have. And I think to a certain degree it works kind of better because you don't have to get into the courtroom early with your computer, hook it up, make sure it works with their camera system, or their monitor system. The judge has to switch between whose laptop is feeding into the monitor. And so as far as just getting in front of the judge, getting the judge's attention, and sharing documents, I think to a certain degree that works better. For depositions, the ones I've done, I had done a remote deposition a couple years ago of a third-party witness. And in that case, what I did was I essentially had my universe of 20 documents that I thought I wanted to use, sent those to the court reporter. So the court reporter was there with those 20 documents. I probably only used 15 of them. And that's what I did for the video depositions I did, where I actually, during COVID, where I actually emailed the documents I was going to use to both the witness and counsel, so they had them in hand. I mean, obviously that broadcasts a little bit of your intent to opposing counsel before you did it, but overall it was still worth it, because I had other counsel in the case who didn't do that and tried to introduce documents on the fly, and then afterwards was, trying to get stipulations about what exhibits were actually used during the deposition, and that did not work at all. So I think having your stack and your universe of documents to opposing counsel and the witness beforehand, even if you end up not using them all, is just worthwhile, and it'll make your record a lot cleaner.
Yeah. When it comes to your the IP clients, I'm reminded of a few weeks ago, we talked with another IP lawyer, and one of the things he commented was, that because they saw during this COVID season that a lot of their IP clients, for lack of anything else to do, sat around and generated a whole bunch of new ideas and things they wanted to get back to, that kind of thing. Have you seen the same type of thing with some of your clients? I know not on the litigation side, but on the patent prosecution side.
Yes and no. I don't do patent prosecution, but we have a lawyer named John Vereb in our firm who does, and he has become very busy. He was very slow, I'd say, till about July, August of last year. Very slow is too strong of a word, but he was slower. But the last quarter of the year for sure, and now he has been very, very busy. Trademarks is a little. I'd say trademark has been a little bit slower, in part because maybe people aren't putting new products. They might be coming up with good ideas, but they're not launching new products onto the market yet, and so they're not as. If they're not launching the product yet, they might put off a trademark application a little bit longer. So I wouldn't say it's been significantly slower, but it certainly hasn't picked up. So I think you're probably right about the patent part of it, especially in the oil field. With the price of oil dropping the way it did, a lot of companies felt the only real way you could differentiate yourself is to be more efficient and have better technology, and so I think that has spurred a lot of patent work in that field.
One question that I hear, I used to hear it a lot when I was talking with law students, and I will still hear it from lawyers that have been out a couple of years as well, and that is people who are doing maybe a general litigation practice or maybe a defense type practice or doing something like that, and want to do IP litigation. With the rub of that they don't have the technical undergraduate background or have the patent bar or anything like that. And it seems as though, depending on the firm and depending on the type of work, that it's that some places you can still do patent and IP litigation without that, and then others it is more required or at least highly preferred. What are your thoughts on that? And for someone that maybe doesn't have that technical undergraduate background, how can they get into the area?
Right, and I'm one of those people who didn't have a technical background. I was a sociology and economics major, so I knew I liked. I come from a family of engineers, so I think that little part of my brain might be in there somewhere. And I kind of wish I'd taken more science in college now, especially chemistry. But I had the same experience. I wanted to do IP. I mean, I went to law school at UCLA, and so a lot of the reason I went out there was I was sort of more interested in what people call the soft IP, copyright, trademarks, advertising, entertainment, that kind of thing. I actually went out there because I wanted to be an entertainment lawyer, I thought, and I ended up liking the law more than I thought I would, and the law generally, and became interested in patent law. So I was the same situation. I would interview with firms, and when you say IP firm, 97% of those firms are patent firms,
right?
And so I was in the same situation. And in interviewing, there you got a lot of the, well, you don't have a technical degree. We don't hire people with that technical degree. My experience, at least, when I got in the big firm, and I've heard the same from others who don't have technical degrees but ended up in IP, is as soon as you get in the door at these big firms and you say, I want to do IP litigation, they'll say, sure, we're always happy to have bodies to throw at a big patent case, because those are some of the big, other than maybe antitrust cases, and there aren't as many antitrust cases anymore, I don't think. Those are some of the biggest cases, the most document intensive, the most people you're going to need. And, some of these bigger firms, you're going to have you might have an 8 or 9 person team, and you can certainly have 1 or 2, if not more, people without technical degrees on that team. And my view on it is I think to a certain degree, sometimes it's an advantage, because at the end of the day, you're going to be dealing with a judge who probably doesn't have a technical degree, and you're going to be dealing with jurors who don't have technical degrees. And if the scientists and engineers you're dealing with are on a level 10 or 8, or 10 or 9, and you can, I'm on about level 7 and the jury's on about level 3 to 5. If I can't understand it, I'm not going to be able to explain it to a jury. So part of my learning process and how I learn about technology is how I end up explaining it to a judge or a jury at the end of the day. So I think my advice is, if you're interested in IP and you want to, and you don't have a technical degree, is go to a big firm in the general litigation department and let it be known that you want to do IP litigation, or you may just very well end up doing IP litigation just out of happenstance because a big case is going to come up. I mean, that's what happened with me. I was in the general litigation department, and 2 weeks into it, there was two lawsuits between Exxon and Mobil when they were separate companies related to patents. And so, the next 2 years, I spent 75% of my time on those 2 cases. So if that's what you want to do, and maybe it'll take longer than 2 weeks for it to happen, but if you're at a big firm and you're in the litigation section, the opportunities are there.
Awesome. Yeah. So hopefully people listening there that are in that situation, you have some hope now and you have a little bit of a roadmap. So that's exciting. So Keith, when you first got started in practice, what's maybe something that you learned in those early years that helped you develop as a lawyer and is still something that you cling to today? It's an important part of your practice. What's a piece of advice that you got early on? Yeah,
a lawyer named, who I didn't know that well at the time, but I've come to know a lot better since. There was a lawyer named Lee Kaplan who was leaving Baker Botts, and we were talking briefly, and he gave me one of the pieces of advice. He gave me 2 pieces of advice. One was, if a partner asks you to do some work and you're really too busy to take it, is just to act as agonized as possible to say you really would like to work with it, but you just can't in this case. But the thing I think is the second piece of advice he gave me that I think is the most practical is if you've got a difficult decision to make in a case, and there's several different options, not to rush to make that decision, but at a certain point you just need to make a decision and move on. And so rather than agonizing for days on end about a particular decision about where you should go, what a particular question you should ask in discovery, or things like, or how you should approach a motion, just make a good, smart, intelligent, well thought out decision and then move on, and don't dwell on that, and deal with the case as it is at that point once you've made that decision. So I think at a certain point you just need to, if you've got something that's hanging over your head that you really don't want to get to and you're sort of pushing it off, at a certain point you just need to sit down and get it done, and then move on and deal with the consequences in your case. And at least where you are and the decision you've made and how you have to move forward in the case at that point.
Yeah, kind of that analysis paralysis that a lot of us can get in trouble with.
Exactly.
As to your first point that Mr. Kaplan gave you, I'm glad you mentioned it because it's something that I talk with lawyers a lot about and get asked questions about is, when the work's piling up and when, especially in the situations where you're not maybe working for one particular partner, but you're getting work from multiple partners. And oftentimes they're maybe not communicating about what work they're giving to associates. So when that happens and it piles up, the response to a partner, when you are starting to feel like you're at the top of your capacity level. That's interesting. I thought that the way that you described his advice there about the agonizing over not. Have you seen that play out? And do partners take that in different ways? Do they just always expect you to still find a way to get it done practically?
Right. I mean, I think maybe some practical advice coming out that is not necessarily to say no right away, but to say, well, when do you need it? Because if somebody says, hey, do you have time to do this? If you just say no, then it's, well, I went to this person once and they said no when I tried to give them work. If you say, well, I'd love to help you. I've got this, and this to do the next 3 days. Do you need it? When do you need it? Because sometimes you don't need it for a week or two. Right. And if somebody can take care of it on Friday, even though you're asking about it Monday, that might be plenty early. So I think, as it's, I can't do it right now, but I'd love to do it, as soon as, or if you don't find somebody else to do it, come back to me or something like that. The more you can show your willingness to help out, even if you physically cannot at that point in time, the better that's going to serve you in the long run.
Yeah, that's great. Is there anything that you picked up later in practice that you wish someone had told you when you were getting started?
I think one thing is briefs really are supposed to be brief. Motions for summary judgment are one thing. I mean, those have to be long, especially if you're in a lot of cases, if you have to either disprove someone's case or if you have to make sure you get enough evidence on to avoid summary judgment. But, for the most part, state court, I think especially because they don't have as much clerk help, if you're going to a docket where there are 10 cases being heard and even if your brief is 10 pages long, the judge may not get to read it, especially if it's a small issue. Mm-hmm. So I think, if you can write a 3-page brief on a particular issue, I think when I was a young lawyer, I thought, well, did I really do enough work on this if it's only a 3-page brief? If you can make the point in 3 pages, I think judges are going to welcome that. If you've got 1 or 2 good cases to make a point, that may be all they have time to absorb. You don't need, 4 to 5 page discussion of the detailed facts of 3 or 4 cases and then a big string cite with 15 more cases at the end of that. So I think especially if it's a relatively minor issue that you have a hearing on, the shorter you can keep it, the better.
Yeah. What's the line? I don't want to misattribute it. I was thinking Mark Twain, but I would have made it shorter, but I didn't have time.
Exactly. Yeah, exactly. And it's hard sometimes. Sometimes it's just not possible. But,
right.
The more you can try to do, the more you can stay short of the point at which you have to do an index and a table of authorities and a table of contents, the better off you'll be.
When you're evaluating or observing young associates, what's something that impresses you? What stands out?
I think someone taking initiative and someone really, at the end of the day, just caring about the quality of the work, and taking ownership over an issue. And what I don't like is if I get a draft that essentially, if I ask somebody to work on something and I get a draft that essentially looks like literally a first draft, that's a problem. Where I have to do the editing and the spell checking and the corrections and things like that. Even when I write a draft, if I give it to somebody else to look at, there's going to be typos in there. There's going to be phrases that are awkward or that don't make sense. I get that, and I'm not talking about that. It's just it seems like literally somebody wrote something and then didn't read through it a second time. I mean, I rarely write anything, certainly not that gets filed or that even show to anybody else, where I don't go through it at least 4 times. And sometimes the first draft I do something is just I read it immediately afterwards, and there are parts of it that are just horrific. So
Right.
it's and to quote someone else again who I can't exactly remember, like you could, writing is rewriting. I mean, that's really all. Rarely, unless you're really strapped for time, you don't usually write a first draft, maybe proofread it in 10 minutes and get it on file. There's a lot of rewriting that goes on to make something that's even palatable for a court or for anybody else for that matter.
Yeah, absolutely. What would be your advice to associates from the standpoint of how to think about developing their own business or developing clients? I think a lot of associates in those first few years can struggle with that, particularly if, really they're trying to focus on just becoming, a good practitioner. And then trying to balance that with, okay, but then I'm going to wake up 6 or 7 years from now and I'm up for partner or whatever, but I don't have any business because, so I think that's sort of an internal conversation that a lot of lawyers are having. What are your thoughts on that?
Yeah, it's hard. I mean, it's not easy to develop business when you're new to the career and young. One thing I tell people is most of the work I get is based on something I did 3 to 5 years ago. Somebody I met 3 years ago, somebody I met, somebody I had a class with 5 years ago. I think being a member of different subgroups of bar associations is helpful. I mean, for instance, I'm a member of the entertainment, sports and entertainment section of the Houston Bar Association. I've been the president a couple times, mainly because it was my turn, and we sort of rotate through.
Yeah.
And I'm sort of the IP guy in that group. People know, hey, Keith does IP stuff, and so a lot of times I get called as the IP person. So even if it's not something that is necessarily your core area, if you've got a subspecialty that you're developing and you get with diverse groups where you might be the only person that they know with that specialty, that's worth doing. And it's very rare, especially if you're in litigation, that you're going to happen to meet somebody at a cocktail party, and just to use a cliche, and they're going to say, "Oh, by the way, I just got sued today. Would you like to handle my multi-million-dollar litigation for me?" That just doesn't happen. But you meet that person and you exchange cards and you talk about what you do, and 9 months later, maybe they do get sued, and maybe they do reach out to you, and sometimes it's not even a kind of a law that you do, but you refer them to someone else, and then they remember you because you weren't the person who just said, "Oh yeah, I can do ERISA litigation," even though you've never done ERISA litigation. You've at least helped them out in some way, and they're gonna value that and come back to you for something that's more within your core area of competence.
Yeah, I love that. And I love the multiplication effect of that, because not only do you make that client happy getting them with the right person, but then you also have now done a good deed for that other lawyer who's getting that referral. And so now you kind of have 2 people that are happy with you and all of that. And it just multiplies out from there, doesn't it?
Right. And it doesn't hurt either to say, look, if you just have any questions, give me a call. And I'm always happy to talk for 10 minutes. Or, people call me sometimes with little questions like that. And it doesn't make sense for me to try to set up a client and send a engagement letter for 10 minutes of work. So I'm always happy to talk with somebody about something. I mean, you get into attorney-client privilege issues there. Not that there's not some risk in doing that, but if it's just sort of informal legal advice of, hey, here's some way you can handle that, and you've at least, where they're not to the point that they really need to engage a lawyer, that kind of thing. They're gonna know that you're a resource that they can call as soon as trouble might be on the horizon, and then when trouble really does flame up, then they will have already talked to you about it, and they might be willing to hire you.
Yeah. Last topic that I want to cover today is on hiring and recruitment. So when you're looking at resumes, thinking about hiring a lateral attorney that's been out for a couple of years or something like that, what are some of the key things that you're looking at, maybe on the resume, or just sort of on the documents before you get to the interview stage? What are you looking at and prioritizing on a resume?
Right. I think at least in the cover letter, I mean, resumes are all pretty stale. I don't mean that in a bad way. It's just, you don't see a lot of emotion in a resume. But so the cover letter can matter to a certain degree to show some passion or to show specific experience as it relates to your firm beyond what you can see in the resume. What I've started to do is ask for, once you narrow down candidates a bit, is ask for writing samples to a certain degree, because that can, that it's almost like there's two parts of law school. There's what was your GPA overall and how did you do in legal research and writing, and legal research and writing, or if you were on law review, then that's usually a pretty good indicator that you can write pretty well. But so yeah, I've started to do that, and to a certain degree, if we don't, the initial phase, if you don't have time to look at writing samples for everybody, the cover letter is going to be a pretty good example of their written word and how naturally they sound. I mean, I'm someone who usually doesn't like writing that sounds like it was written to make someone sound like they were a lawyer. At the end of the day, I think I write my briefs in pretty much plain English, as opposed to a lot of flowery lawyer language. And I care more about the clarity of the spoken word than the formality. And sometimes the cover letters can be an indication of that as well.
Yeah. Any cover letter big misses that you recall that you looked at a cover letter and said, whoa.
Yeah, and I know that I have probably filed briefs with, I know I have filed briefs with typos in it or things you catch later that you're kind of embarrassed about. So, one or two typos in a letter wouldn't be fatal, but if somebody, if there's something where there's, subject verb agreement, or it's it says dear and has somebody else's name from another firm in there, that I'm sure you've seen that. That can happen, and I get it. It's honestly, it's an honest mistake and probably something I have done in the past too, but it's still, it at that point you get it. Okay, I'm not really as special as you've told me I am in the cover letter. You're just sending these to 100 firms. So yeah, it's probably worth, if you have someone else who can review something for you, to have somebody else, review cover letters and things like that. Because especially if you're sending out a lot of them, it's inevitable you're going to make typos here and there. But, the more you can minimize that, the better.
Yeah. How about in an interview setting? What's a priority for you to see in an interview?
Yeah, I haven't had too many bad interviews. I mean, I think I'm pretty easygoing from that standpoint. I mean, it's I know when I was interviewing, I gave some terrible interviews myself when I was still in law school, and I just didn't really know. I mean, I could tell you some stories, but that's a whole separate podcast. I should have done some more practice interviews. Let me put it that way. But most of the people I've interviewed, I think, have been pretty good. I mean, I think, you need to be ready to answer the question of like, why our firm? What is it about our firm that interests you? I think that's probably one of the most important questions, as opposed to, I just really need, somebody who really needs a job right now. So, I haven't, I think most people, we haven't hired many people straight out of law school. Really just one corporate lawyer I can think of, and I wasn't involved in the interview process. So I think most of the lawyers we've interviewed who have all been at least 2 to 3 years out of law school, they've all been pretty good at interviewing. I think at that point you've interviewed enough clients and you've spoken to enough judges. You've kind of got your speaking skills down.
Yeah. Well, great. Well, we've got a few rapid fire questions to end our time, but before we do that, is there anything that I haven't asked you about that you would want to share before we move on?
I think the best advice I could give, and it's hard when you're young and straight out of law school, and things are kind of all consuming, but try not to take the job home as much as possible.
Yeah.
I mean, have other hobbies, have other interests. I know it might be difficult right now in COVID times when you are home for both work and home life.
Right.
But yeah, the more you have something else that you're passionate about, the better. And honestly, the more interesting you'll be to clients, the more interesting you'll be to coworkers if you have something other than work that you're passionate about. And, don't hesitate to develop those other things. So I think that's part of a lot of work-life balance is mental. And the more that you have other things that matter to you and that interest you, and or can leave work and focus on the family, the better off you'll be in the long run.
Yeah, that's great. And I appreciate how you, when you talked about that, you kind of have both the practical benefits for your own mental health and physical health and all that, but then also the business and practice benefits of being a more interesting person to relate to for potential clients. When you go to that cocktail party, they don't want to hear all about your law practice all the time, right? They want to hear about something else. Right. And so having that is helpful.
Clients like to work with people that they like generally, and the more you have interests, and the more, if they have a family and they're talking about their family, they probably want to hear about your family too. So it's right. It's or your interests or what have you. So the more you're just a well-rounded person, the better the better it will be. I didn't read for a long time I didn't read for fun probably the first 10 years of my practice, and I have started to do that more often. And I think it kind of has a kind of calming and focusing effect. But it's hard when you're, back when I was at the big firm days and it was, working 8 a.m. to 8 p.m. fairly regularly. The last thing you wanted to do was read more when you got home.
Your eyes were just popping out of your head. Oh, man. Well, all right. Rapid fire questions. If you're ready, we'll go through these.
Sure.
All right. Great. Name the one trait or characteristic that you most want to see in an associate.
I'd say ownership. That if they work on something, that they're going to make it the best that they can, and not say, well, I'll just do enough, and then Keith will fix it.
Great. What habit has been key to your success?
I think that kind of goes back to being able to leave work at work. And I don't know if that qualifies as a habit, but just kind of leaving. And don't get me wrong, I do billing at home sometimes, but I've usually, got a soccer game on the weekends or whatever. I think just, being able to leave the office at the office for the most part. Yeah.
Your favorite app or productivity tool?
Does it have to be professional or does
no, but there's pressure on an IP guy to come up with something good here.
Right.
No, I'm just
kidding. Honestly, I used to like Twitter a lot as sort of a news feed, a self-curated news feed. And it's just sort of been a cesspool of negativity.
Yes, it has.
Probably less, but I still sort of use Twitter and still like it from time to time, though I've kind of shifted away from more legal things and, more personal interest things like, high-end beers and things like that. It's probably still Twitter. I haven't used a lot of the apps in my legal practice very much. I mean, you use LinkedIn occasionally to, check on clients or learn about clients or opposing counsel or whatnot. But we're probably, it's in terms of the time I spend on it, short of podcasts, which I've really listened to a lot the last couple of years. I'd have to say it's probably Twitter.
Yeah, good deal. Your favorite social distancing activity?
Probably running. I mean, if nothing else, to get fresh air and get out and about and see human beings from a distance. That's probably that's probably been my. I mean, that's probably what I've done more than anything else.
I run every morning as well, so that's a good one. I do want to actually go back though, because you mentioned doing or personal interest of high-end beers. Do you have a high-end beer recommendation for us?
I'd say any of the Belgian. I'm really into Belgian style beers, so any of the Trappist beers. Beer I really like recently is Boulevard's Tank 7. It's a saison.
Okay.
That's one thing I did during this. Just a curiosity I did during COVID is I studied for and took my written test for the Cicerone certification, which is like a sommelier.
Like a sommelier beer. Okay.
Yeah, exactly.
Awesome.
So
cool.
They had the tasting on hold since really for the last year. I was supposed to take the tasting in March of last year. And we know how that all worked out. And then it was going to be June, and then I was going to go to Austin and do it. And they basically put that all off until August. So yeah, that was sort of, one of my hobbies. I'm one of those people who's always kind of had something else they're doing on the side, and that's sort of my hobby is learning about that. And it's just the history and all that has just been that I've learned about beer and the methods.
Yeah.
And, there's a little bit of science, a little bit of history. It's all been pretty fascinating.
Yeah, absolutely. Well, that's cool. Okay, last one. Your favorite legal movie?
I would say Shawshank Redemption probably isn't enough of a legal movie. That I've enjoyed most of them. I really liked the Trial of the Chicago 7, which was on Netflix recently.
Yeah.
But as far as what it's sometimes frustrating as a lawyer watching legal dramas over and over again, because then you start to get into rules of evidence and how they're in practice. But as far as the movie I've enjoyed and would watch again, My Cousin Vinny. That's
a classic, for sure, and a favorite. But I am glad you mentioned Trial of Chicago 7, latest Aaron Sorkin movie, and it is on Netflix, and it is very good. So if you haven't seen it yet, you should go check it out.
A lot of courtroom time, and nothing that infuriated me. Other than certain actions of the judge, which were obviously the focus of what was.
Yes.
But as far as like the actual behavior of the lawyers and whatnot, it was it seemed to be pretty realistic and pretty genuine.
Yeah.
It was a good movie.
That's awesome. All right, well, Keith, thanks again so much for coming on the show. We appreciate getting the chance to spend some time with you, and wish you the very, very best.
Thanks, Daniel. Thanks for having me.
All right, my thanks again to Keith Jaasma for joining us on the show today. If you enjoyed this episode, would you consider doing two things for me? Would you subscribe so you don't miss an episode? And then would you rate and review the podcast in Apple Podcasts or wherever you listen? If you have suggestions or thoughts about the show, or if I could help you in any way, please email me, daniel@varsitysearch.com. Also, don't forget to reach out if you're interested in any of the opportunities that we mentioned earlier, or if you'd just simply like to visit about the market and what options there might be for you out there. Would love to hear from you. All right, that's it for today's episode of Lone Star Lawyers. Thanks again so much to each of you for listening. I'm Daniel Hare with Varsity Search, and we'll talk with you next time.